Hello everyone, welcome to Oliveboard. This is the CIB Foundation July 2025 BRBL series, and today we are going to start with the unit 9 of our module B, which is the Negotiable Instruments Act of 1881. So all the videos of the previous chapters have been uploaded on the YouTube channel. If you haven't yet seen them, or if you have missed any video, make sure that you watch them. Today we are going to start with this Negotiable Instruments Act, which came in March, or which was enacted in March 1882, and it presently extends to the whole of India. So this law governs the making, negotiation, and the payment of the negotiable instrument, including a check and other negotiable instruments act like the bill of exchange and a promissory note. Although these haven't been explained, or these haven't been described in the act, but we use the same meaning of the negotiable instrument, which means a promissory note, bill of exchange, or a check, which is given in section 13. So now let us start. We are going to cover two important sections which have been introduced: section 143A and the effect of insertion on the section 148, and then we will also talk about the protection that is provided to the paying and the collecting banker. So let us start with this unit. All right. Foremost, the most important thing of this chapter is the insertion of section 143A in the act. So with this insertion of section 143A, what changes have been made? This new provision was introduced wherein a competent court, while trying a check dishonor offense, is empowered to order the drawer of the check to pay interim compensation not exceeding 20% of the check amount to the complainant, where the drawer pleads not guilty to the accusation. So dishonor of the check. In the check which is signed in the name of the drawer and the drawee is responsible to pay for it, if the person on whose account the check is written, if they do not have sufficient fund, then we will say that the check has been dishonored. All right, that it has been dishonored. When such person says that no, I did have the sufficient fund, and they plead not guilty on a complaint that was made, then for that, the section 143A says that first you need to pay a 20% of the amount which is given in the check, right? This is the compensation which will be stated by the competent court, that this is the compensation, and 20% of the check amount will be paid to the complainant, and then the case will be taken further. This is given in the section 143A. Further, it also states that this compensation, this interim compensation, has to be paid within a prescribed time period of 60 days from the date of passing of the order by the court, and then it can be extended to 30 days if significant cause for the delay has been provided to the court. All right, so first thing, that whenever here the check dishonor offense is brought to the court, then the appeal can be laid that the dishonor was not there, and here the order will be given to the drawer of the check to pay the interim compensation not exceeding 20% of the check amount, where the drawer says that they are not guilty of the accusation made in the complaint. So this is given in the section 143A. So what is the effect of this insertion of section 143A? Through, so the amendment was inserted through section 148, that in the case of an appeal which is filed by the drawer against the conviction under section 138, so the bank, they can file the case of dishonor with the court, but the drawer then says that they are not guilty. So now what will happen under section 148? Then the appellate court may order the appellant to deposit such sum which shall be minimum 20% of the fine or the total compensation which is awarded by the trial court. So for the appeal to be taken further, first the appellant will have to deposit 20% of the compensation which is awarded by the court. Then it will be taken further. So this is given, or this is the change that has been made with the insertion of section 143A. Right. Then if we talk about the negotiable instruments, their types and characters, so this is given in section 13 of the Act. Section 13 of the Act, that negotiable instrument will mean a promissory note, a bill of exchange, or a check which is payable either to order or to bearer. So either an order check or a bearer check will be treated as a negotiable instrument, right? Then the basic characteristics, there's a contract between two or more persons in a negotiable instrument. Then this, it should be in writing, it should be in a expressed in a particular currency. Same things that we already know about the negotiable instruments. So there are presumptions as to the negotiable instruments, which are given in section 118 and 119. The presumptions of consideration as to the date, as to the time of acceptance, the time of transfer, that the holder is a holder in due course, right? We will see what is the meaning of holder in due course. These are the things. Now, when we talk about these instruments, so I have put them in a chart wherein the difference between promissory note and a bill of exchange is given. Promissory note is where there are only two parties, maker or the debtor of the promissory note and the payee or the creditor of the promissory note. It contains an unconditional promise by the maker to pay the payee, and here no prior acceptance is needed. The liability of the maker or the drawer is primary and it's absolute, and no notice of dishonor need be given. These are the characteristics of a promissory note, where we promise to pay the payee certain amount. Then we have the bill of exchange, where there are three parties, the drawer, the drawee, and the payee. The drawer, the drawee, and the payee. It does contain an unconditional order to the drawee to pay according to the drawer's directions, and the bill payable after sight must be accepted. In the promissory note, prior acceptance is not needed, but in a bill of exchange, the prior acceptance is needed before it is presented for payment. The liability of the drawer is secondary and conditional upon the non-payment. And finally, the notice of dishonor must be given by the holder to the drawer and intermediate endorsers to hold them liable thereon. Right? So these are the basic characteristics or basic difference between promissory note and a bill of exchange. Then we also have the difference between a check and a bill of exchange. Check can be drawn only on one banker, only on a banker. But the bill of exchange can be drawn on any person, including a banker. Check is drawn only on a banker, right? The amount is always payable on demand in a check, and check is not entitled to the days of grace. Here, acceptance is not needed, and check can be crossed if required. The notice of dishonor is not necessary. It is not to be noted or protested, and protection is given to the paying banker. This is very important. Where the protection will be given to a paying banker in the case of check, where let's say there is a material alteration which is not apparent. We will see the provisions related to it. So the protection will be given to the paying banker as well. Under which section we will see. So now for the negotiable instruments, we see that there are certain terms, like the drawer is the maker of the negotiable instrument or the bill of exchange. So these terms, I hope you are familiar with the terms. Drawer is the maker of the bill of exchange, right, or the check, and person who is directed to pay is known as the drawee. Directed to pay. Directed to pay is the drawee. Then drawee in case of need will be a third person which will be resorted to if the drawee, if the need arises, right? If there is any endorsement, so that is the drawee in case of need. Acceptor will be that after the bill has been signed, or if there are more parts, all of them have signed to it, then any person who is the holder on behalf is known as the acceptor. Then acceptor for honor is there, and payee is the person who is directed to be paid. So payee is the person who is to get paid. These are the three main terms, the drawer, drawee, and payee. Then we have the drawer in case of need, acceptor for honor, and the acceptor. Right. Then if we talk about the payment of checks, so there is certain protection that is provided to bankers as well as the customers, right? So first we have the banker's duty to pay, which is given in section 31 of the act. The drawee of the check that is having sufficient funds of the drawer in his hands properly applicable to the payment of such check must pay the check when duly required to do so. So this is the duty of the banker to pay the check if the drawer has sufficient funds in their account. Everything is according to the provisions, the amount is mentioned, it is signed, and it is a legal contract. Then they, and also if there is any default in such payment, then they must compensate the drawer for any loss or damage that is caused. Then payment in due course, if the payment is done in due course, if the check is made in due course, then the paying banker will be provided protection. If let's say the banker had taken all the necessary precautions, due diligence, they had seen the apparent tenor, they had seen the person was in the rightful possession of the instrument, but anything because of any material alteration that was not apparent, it was not the fault of the bank, then they will be provided protection. Protection will be provided in terms of section 85. Section 85, against fraudulent endorsements of the payee or other endorsees, right? So in terms of section 85 of the act, protection is provided to the paying banker against fraudulent endorsements of the payee or other endorsees in an order or bearer check, right? If the payment is made by the banker in due course, that it was not very clear that the changes that were made, they were against the provisions of the act, right? So the bank had taken due care, they had used all the preventive measures, all the vigilance, then also any fraudulent activity has occurred, then the bank will be provided additional protection, right? So the conditions that are to be fulfilled for protection, right? So that there was no doubt that the payment of the check had any question, right? It was accordance with the apparent tenor. Then the check was not crossed and payable to the plaintiff or the order, right? Payment was made in good faith and without any negligence. All of these things, if they are seen, then protection will be provided to the banker. Now, when we talk about material alteration, let's say we have a check in this form and it is in the name of a person, let's say X, Mr. X. If what happens, the amount which is mentioned here is 20,000, and the person does what? They fraudulently, without informing the bank or without informing the drawer, they do what? They add a zero to it. Now here it wasn't cancelled or it wasn't marked, so zero adding, and it is not apparent to the banker, right? But it is a very substantial alteration that has been made. Or this person X name is changed to Z. This is also a material alteration. So whenever any alteration substantially alters the instrument, it substantially alters the instrument and it is without the knowledge of all the parties involved, then irrespective of whether the alteration is beneficial or prejudicial, it will be known as a material alteration, and it will be termed as a fraudulent activity. So alteration in the date of the instrument, alteration in the name of the payee or the beneficiary, alteration of the amount, which is the most common type of fraudulent alteration, alteration of an order check to a bearer check. If anything is done without the knowledge of the other parties or the bank, then it will be a fraudulent transaction or a material alteration, right? Now, section 89 says that where payment is made by the bank on presentation of an instrument which is forced by alterations which are not apparent, which are not visible, which are not clear to the naked eye. If a check is an electronic image of a truncated check, then any difference in the apparent tenure of such electronic image should be considered as a material alteration. And it will be the duty of the bank to cancel the check, to not make the payment if there is any change, if they're even suspicious of it, right? So any bank, they if they receive any image or it is different from the original, then they need to cancel it out. All right. So then section 89 says that if any change is seen as from the naked eye that it has been altered, the check has been altered, then it is to be treated as void, erroneous, or fraudulent alteration, right? It should be visible to the naked eye. Now, there were many cases in which court decisions were taken in favor of the bank, wherein the material alteration was not apparent, right? And the banks were given protection. Now, what is the protection that is provided to the collecting bank? To the collecting bank, there are certain terms that we need to know first. First, we have the holder. Section 8 says that to be a holder of an instrument, the person should be entitled in her or his own name to the possession. If you find a check lying down on the road anywhere and you take it to the bank, you will not be known as the holder. All right, so that holder, you should be entitled, the instrument should be in your name, to the possession of the instrument or to receive or recover the amount, which implies that the holder does not include a person who through a possession of the instrument has not the right to recover the amount of the instrument. So you should be entitled to the instrument, right? This is given in section 8 of the NI Act. Then holder in due course, this is given in section 9. Holder in due course means any person who for consideration becomes a possessor of a promissory note. Consideration, which is a two-way contract. So if for consideration they become the possessor of a promissory note, bill of exchange or check, if payable to the bearer or the payee or endorsee, or if payable to the order, then the amount mentioned in it becomes payable and without having sufficient cause to believe that any defect existed. Alright, so for consideration, if the instrument is passed on to another person for the same amount that is to be paid, then it will not be considered void. So that person will be known as the holder in due course or in the right manner. That is given in section 9 of the Act. Then we have the holder for value. So when a bank, to oblige a customer for any reason, they pay the amount of the check drawn for on another bank before its collection, then the possession of the bank who is paying the customer is the holder for value. So the bank who is obliging the customer, they are paying the amount of the check that is drawn on another bank before its collection. They will become the holder for value. Now, when we talk about the law that provides protection to the collecting bank, so the protection to the collecting bank is provided in section 131 of the Act. According to this, a banker who has in good faith without negligence received payment for a customer of a check that was crossed generally or specially to himself, in case the title of the check proves to be defective later on, they may incur any liability to the true owner of the check by reason of only having received such payment. So if a banker, they have made the payment in good faith and without any negligence, then they shall not incur any liability if later on the check is found to be fraudulent, right? If it is later on found to be fraudulent. So this basis of protection is only for the cross check, and statutory protection is available to the collecting bank only for the cross check, right? Not where the drawer signatures are forged. So they need to make sure that the drawer signatures are correct, and then collection should be done in good faith and without any negligence. Collection should be done on behalf of the customer only. Verification of the genuineness should be done. So the if the electronic image of a truncated check is received, then the bank should have verified the apparent genuineness. They need to make sure that all the information that is given is correct. Further, if there is a dishonor for the check of insufficiency, let's say, in that case, the section 138 provides for the provision, right? So where any check is drawn by a person on an account that is maintained by him, but it is returned unpaid by the bank because of there is insufficient money in the account, then it is punishable. That person, they can be punished with the imprisonment for a term which may be extended to 2 years, or a fine, or even both. All right. So the check has been presented within the due time, within the due tenure, but it has been disordered. So section 139 says that the presumption in favor of the holder will be there. Section 141 says that offense when it is conducted, then it will be punishable. All right. And then we have already seen the procedure under section 143A, which has been inserted, that under the code of criminal procedure, the court is going to take the offense. All right. So these are all the important points regarding the Negotiable Instruments Act. So you need to remember the compensation which will be paid by the appellant under section 143A. Then the amount, it will be deposited within 60 days from the date of the order. Higher appeal also lies, but not beyond that. So these are the basic main provisions. So when you study this chapter, make sure that you pay special attention to all of these sections that we have discussed. If you want to study this chapter or other chapters in detail, then you can join the CAIIB selection batch for the June-July 2025. This is all in one course, and you can get the details from the description box. The link is available. You will get all the subjects classes, the basic concept clarity, doubt sessions, revision classes, downloadable notes, numerical based test, and elective paper tests as well. So you can enroll now, you can see the details, and you can join the course. These batches will be available both in English as well as the English medium, and it is going to be a live batch. So make sure that you enroll now. That is all for today. We have completed the unit 9. We have summarized the Negotiable Instruments Act, all the provisions that are important. And now I will meet you again in the next session with the next chapter.